Hi, I'm Aishwarya Venkatesh. Anybody can become a professional without any qualification. Sounds interesting, right? Yes, it is possible. We all go through a litigation process for dispute resolution. That is, we go to court for seeking justice. But there are many other ways in which we can solve a dispute outside a court, which is known as alternate methods of dispute resolution (ADR). Primary legislations dealing with ADR are Arbitration and Conciliation Act 1996, Legal Services Authorities Act 1987, Code of Civil Procedures 1908. Some of the methods in ADR are arbitration, conciliation, mediation, negotiation, etc. In this video, we are going to ponder over arbitration in detail. Also, we'll look at conciliation and mediation briefly. So, I'm going to explain it in very simple terms with our examples in real life. First, arbitration. How does this whole process work? Let us consider an example to understand it. There are two people, Tanu and Manu. They are husband and wife. They have some petty issue within themselves which they don't want to take it to court. They want to solve this issue outside the court and they choose arbitration process for that. So what they have to do? They have to appoint an arbitrator who will act as a judge and give a final and binding decision which is called as arbitral award. How will the final and binding decision be arrived by the arbitrator? Tanu will prove herself correct and Manu wrong. Manu will prove himself correct and Tanu wrong. Finally, after all the discussions, they both will arrive at a conclusion. The arbitrator will monitor the whole event and consider the conclusion that is arrived as a final and binding decision. Indian Council of Arbitration fixes arbitrator's fee according to the amount that is involved in the dispute. You can earn lakhs too. Now, there might be some basic question that would have arisen in all of our minds. That is, whether there is no qualification required for being an arbitrator? Absolutely no. There are only two simple conditions that are to be followed. First, arbitrator should be capable of contracting. That is, he should have sound mind, he should not be a minor, he should not be an alien enemy or a convict or an insolvent. Secondly, he should not be biased. That is, he should be independent and impartial. What are the legal procedures to be followed to enter into an arbitration process? The parties to dispute, that is in our examples Tanu and Manu, shall enter into an agreement in which they have to mention their consent to submit their dispute to arbitration. Such agreement is called as arbitration agreement. There is no particular format prescribed for it. For example, Tanu murdered Manu in anger. Can this issue be sorted out through arbitration? No. Disputes submitted in arbitration should be arbitrable. That is, law should allow arbitration in that case. There are certain matters which can only be decided in court. For example, criminal offense, matrimonial disputes, guardianship matters, etc. Let me give you some examples where dispute is arbitrable. First, Tanu is an employee and Manu is an employer. Tanu has not worked properly, due to which Manu has incurred some losses in his business. Due to this, there is a dispute that is arising between Tanu and Manu. This can be taken to an arbitrator for resolution. Second example can be, Tanu and Manu are neighbors. They have some problem in sharing of the street road maintenance cost. So because of this, there is a dispute between them and this can also be taken to an arbitrator for resolution. Now, another question. How many number of arbitrators can be appointed to resolve a dispute? Any number of arbitrators can be appointed except even number of arbitrators. Guess why? Very simple. Because if there is even number of arbitrators, then there are all possibilities of issue arising within themselves regarding the derivation of the final decision. For example, in case of 4 arbitrators, 2 may support Tanu and 2 may support Manu. In that case, the problem will arise within themselves, right? So because of which, even number of arbitrators are not allowed. Our next topic is that if all parties to dispute, that is in our examples Tanu and Manu, are Indian nationals, then that arbitration is called as domestic arbitration. Arbitration can also take place if any party to the dispute is not an Indian national. In that case, the arbitration is called as international commercial arbitration. Arbitrator can be of any nationality of one of the parties. Second concept, conciliation. Here, the parties to dispute don't fight with each other. That is, they don't prove each other wrong, like how it happened in arbitration. Here, the parties to dispute come to a settlement after discussion. The conciliator, like how we had an arbitrator in arbitration, there is a conciliator in conciliation. So the conciliator just serves as a monitor, like how it happened in arbitration. Here also he serves as a monitor. Thus, the only difference between arbitration and conciliation is that in arbitration, the parties to dispute fight with each other to come to a decision, but in conciliation, there is settlement. Third concept, mediation. The final decision is given by the mediator and the parties to dispute shall accept it. So as you see, it is similar to court, but the only difference is the dispute resolution happens outside a court premise. I hope all of you would have got a basic idea of ADR. I believe that it would help somewhere in all of our lives. Until I meet you with another interesting video, take care and stay safe.